Okay, good afternoon, everyone. We will go ahead and get started. I'm Mesa Frank, and along with my partner, Richard Landon, we'd like to welcome you to our Franchise Year in Review webinar. I'll give a quick introduction of myself. I'm a partner in our Washington, DC office, a member of our franchise and distribution practice group, and I am primarily a litigator. I represent franchisors in all kinds of disputes, including terminations, the enforcement of covenants not to compete and other restrictive covenants, and the enforcement of Lanham Act litigation and other business disputes. In addition, I serve with Richard as an editor of the Franchise Memorandum by Lathrop GPM. Over the course of the next hour or so, we're going to discuss some of the most interesting cases from our 2020 Franchise Memorandum issues, which span a few important topics. But before we begin, I have a few housekeeping notes. First, we welcome your questions throughout the presentation. So if you have a question at any time, please use the chat feature to submit those, and we'll get to as many as we can at the end of our presentation. We'd also be happy to follow up with you after the webinar if we can't get to your questions today. Second, this webinar will be recorded and will be available on our website by Monday, along with a copy of the slides. You'll all receive a follow-up email directing you to that page on our website. We welcome you to share the materials with others in your organization as well. Finally, CLE credit has been sought in Missouri and Minnesota, and follow-up information will be sent to you upon approval. Now I will turn it over to Richard, who will introduce himself.
Thank you, Mesa. I'm Richard Landon. I'm a litigator and appellate specialist in the Minneapolis office. My practice mainly focuses on advising and representing manufacturers, distributors, and franchisors with antitrust and dealership disputes, as well as other trade regulation and competition law issues. As most of you likely already know, on January 1st, 2020, Gray Plant Moody and Lathrop Gage combined to form Lathrop GPM. In connection with that combination, the monthly publication formerly known as the GP Memorandum was reformatted and renamed as the Franchise Memorandum by Lathrop GPM. Mesa and I are proud to help the new firm continue providing these legal updates regarding noteworthy cases to our franchise and distribution clients and friends on a monthly basis. Mesa?
All right, thanks, Richard. So we'll jump right into it. Our first topic today is joint employer. On the joint employer front, 2020 began with some rulemaking. In January, the Department of Labor issued its final rule, which defined the standard for joint employment under the Fair Labor Standards Act. It was the first revision of the standard in over 60 years. The new rule adopted a balancing test that focused on the potential joint employer's exercise of control over the terms and conditions of the employee's work. Under the test, courts are supposed to evaluate 4 factors. First, whether the company can hire or fire the employee, whether it supervises the employee's work schedule or other conditions of employment, whether it sets their rate and method of pay, and whether it maintains the employment records. Of these factors, no single one is dispositive. For example, the maintenance of employment records alone would not indicate joint employer status. Other factors might be relevant, but only if they would indicate that the company is exercising significant control over the terms and conditions of the employee's work. Now, this rule was a departure from prior guidance, which considered the employee's economic dependence on the company or the, quote, economic realities of the situation. Instead, this new rule considered only actual control and not a right to control. And simply reserving the right to control working conditions would not be enough under this rule to be found a joint employer. Of particular importance to the franchise community, the rule specifically identifies certain business models, including franchising, that do not automatically indicate joint employer status or make it more likely that a joint employer relationship exists. Now, soon after the announcement of the rule, a group of attorneys general filed suit seeking to have the new rule vacated. And in September, the Southern District of New York granted summary judgment in favor of the attorneys general, and struck down the vertical joint employment portion of the Department of Labor's new rule, which is the portion that generally affects franchises. That's in the New York versus Scalia case. The court struck down the rule on several grounds. First, it found that it was contrary to the text of the FLSA. The court noted that, unlike the FLSA, the new rule focused only on the definition of employer, and it ignored the definition of employee and employ in the joint employer inquiry. The new rule also attempted to draw a distinction between whether an entity is an employer or a joint employer, and that distinction does not exist under the FLSA. It also contradicted the DOL's past positions on the issue. The court also found that the rule put too much emphasis on control as the touchstone of joint employer liability, and that emphasis was a departure from prior FLSA case law. According to the court, the Department of Labor also failed to adequately justify its departure from its previous standards. It did not consider the costs of the rule to workers, and it improperly excluded a consideration of whether an employee was economically dependent on the potential joint employer. Now, the defendants in this case have filed a notice of appeal, and they will ask the Second Circuit to rule on this decision. We will, of course, continue to monitor the case, and perhaps next year at this webinar, we'll be able to report on the appeal. Also, of course, it remains to be seen what effect, if any, the new administration will have on the Department of Labor's defense of this new rule. In other rulemaking news, on February 26, 2020, the National Labor Relations Board issued its final rule defining the standard for joint employer under the National Labor Relations Act. Under the final NLRB rule, a business must exert substantial, direct, and immediate control over one or more essential terms or conditions of employment. In this case, substantial, direct, and immediate control means that it has a regular or continuous effect on the essential term or condition. So the effect must be more than sporadic, isolated, or de minimis. Essential terms and conditions of employment are defined under the rule, and they consist only of the enumerated list, which you can see here on the slide: wages, benefits, hours of work, hiring, discharge, discipline, supervision, and direction. Now, this list is intended to be exhaustive, so any terms and conditions not listed here are not considered essential. This rule is significant because it represents a return to the pre-Browning-Ferris analytical framework, which required that a party have direct and immediate control over one of the essential terms and conditions of employment to be a joint employer. In contrast, Browning-Ferris had expanded the standard to allow for consideration of a company's indirect control or its right to control the essential terms and conditions of employment. So this new NLRB rule should hopefully provide some clarity and more certainty to franchisors. There were also a few interesting case decisions in the past year or so. In many, but certainly not all of these cases, just like we saw with the rulemaking this year, we see sort of the application of a fairly narrow and precise joint employer standard. So coming into 2020, we had the Salazar v. McDonald's case. So even though this was an October 2019 case, it sort of set the tone for a lot of the joint employer case law that we saw this year. The plaintiffs in Salazar brought claims against both their franchisee employer and McDonald's for violations of California's wage and hour laws. They alleged that the franchisee denied them overtime pay, breaks, and other required benefits. The plaintiffs alleged three theories of liability. First, they claimed McDonald's was a joint employer. Second, they claimed that McDonald's should be treated like an employer under an ostensible agency, or also known as an apparent authority theory. And then they also claimed that McDonald's was directly liable because it negligently failed to prevent the violation. So McDonald's moved for summary judgment, which the trial court granted, and the Ninth Circuit affirmed on all counts. Importantly, on the joint employer count, the court determined that McDonald's was not a joint employer, and it gave three reasons. First, it found that McDonald's did not exercise control over the plaintiff's wages, hours, or working conditions. it also found that McDonald's did not suffer or permit the employment. And that was true, even though McDonald's had provided its proprietary software, which contained some default programming that had led to the wage and hour violations. The court also found that McDonald's comprehensive franchise system did not give it the control over the manner and means of the plaintiff's work that would be necessary to find a joint employer relationship. Now, on the ostensible agency count, the court determined that claims under California's wage and hour law may only be brought against an actual employer, and therefore any claims would not extend to an ostensible agent. Now, the Salazar court's ruling on the ostensible agency count was found to be dispositive in a subsequent case, which is Cruz versus MM869. The court in Cruz granted the franchisor's motion for reconsideration, and it reversed its prior denial of the franchisor's motion for summary judgment on claims brought by its franchisee's employees. Here, the court followed the Ninth Circuit's holding, which found that franchisors are not liable for wage and hour violations of their franchisees under an ostensible agency theory. Our next case is DeFlavis versus Choice Hotels. Now, this was a putative collective action brought by an employee of the franchisee who alleged that she was denied compensation for overtime work. Choice moved for summary judgment on the basis that it was not a joint employer, and the court agreed. It considered some familiar factors. First, it found that Choice had no authority to hire or fire the franchisee's employees. The court also found that Choice did not have the authority to promulgate work rules and assignments or to set conditions of employment, such as compensation, benefits, or hours. The court also found that Choice did not supervise the employee on a day-to-day basis. And on this point, the court noted that periodic inspections of the hotel by the franchisor did not constitute supervision because the inspections were related to simply protecting brand standards and not supervising the franchisee's employees. And then finally, the court found that Choice did not control the franchisee's employee records. And it noted that the fact that the franchise agreement gave Choice audit rights did not amount to maintenance of the employment records because those audits were really aimed at computing royalties and fees due under the agreement and not at employee records. One interesting point here, the court also noted that the franchise agreement explicitly stated that the franchisee was an independent contractor who had sole responsibility for personnel matters. The next case is Al Sayed versus Family Fare. And here, a corporate franchisee's owner and her spouse/employee each alleged that they were jointly employed by the franchisor. The plaintiffs brought claims for unpaid overtime under the FLSA after the franchisor terminated the franchise agreement. So initially, the claims survived a motion for judgment on the pleadings, and that's in the February decision. Even though the franchise agreement here explicitly stated that there was no employer-employee relationship, the court found that the degree of control that Family Fare allegedly exercised over the plaintiffs could permit the conclusion that there was a joint employer relationship. On summary judgment, however, in that August decision, the claims were dismissed. On the control factor, the court observed that Family Fare did not have the ultimate authority to hire or fire any employees of the store, nor did it control the payroll or taxes of employees. The court noted that even though Family Fare provided an individual who acted as sort of a day-to-day liaison for operational support, now his role was, again, to enforce brand standards and not to exercise control over the employees. Similarly, the franchisee was Family Fare's independent contractor and not its employee. She controlled the key aspects of her work, such as her schedule. She ultimately determined her store's profits and losses. And in fact, she considered herself the employer of the workers at the store. An interesting point here is the court also recognized that most courts have not imposed joint employer liability on franchisors, and none have done so in the FLA context. And this court chose to follow suit. finally, we have a few more cases that apply some of these same factors. In Acharya versus 7-Eleven, a franchisee's employee brought claims under the FLSA against the franchisee and 7-Eleven as a joint employer for failure to pay overtime, among other things. And here the court granted 7-Eleven's motion to dismiss, finding that the plaintiff failed to plead facts demonstrating whether 7-Eleven had hiring and firing power or the ability to control his work schedule and employment conditions, which included hours worked and pay received. Similarly, in Stewart v. Chick-fil-A, a California court dismissed discrimination claims brought pro se by a franchisee's employee against Chick-fil-A. Again, the court found that the plaintiff failed to allege that the franchisor exercised day-to-day control over the details of the employment. And so it could not be found liable as a joint employer. Now, in each of these cases, we're seeing that courts are examining whether the franchisor had control over certain terms and conditions of employment. We often see courts look at the power to hire or fire, the power to determine what the wages will be or the employee's schedule. Sometimes these issues can be resolved on a motion to dismiss, and we saw some of those decisions. Other times, it will require a more detailed examination of the evidence and might need to be resolved on summary judgment. But in each of these cases, the franchisor was ultimately successful. So our final case here is just sort of an interesting one, Marty v. Jackson Hewitt. In this case, some claims were allowed to move forward. Some claims that alleged that Jackson Hewitt was a joint employer of the franchisee's employee. And the real issue in this case was whether an Oklahoma statute, which expressly states that a franchisor shall not be considered the employer of a franchisee or a franchisee's employees, should be applied retroactively. The statute became effective on November 1st, 2016, and it was enacted in response to the Browning-Ferris case. Now, the plaintiffs essentially conceded in this case that any claims that arose after that date were precluded, but they argued, and the court agreed, that absent clear legislative intent that the statute was meant to apply retroactively, it did not. And so whatever claims arose prior to November 1st, 2016 were allowed to go forward. So hopefully that just gives you, some sense of the joint employer issues that arose this year. As you can see, courts, again, are really focusing on the right to control just the certain terms and conditions of employment. And, we'll see with the, continued rulemaking, and in particular, the Department of Labor's new rule, whether that trend continues. So with that, I will pass it along to Richard.
Thank you, Mesa. One area that's always of particular interest to franchisors is their ability to obtain injunctive relief to enforce non-compete covenants against recently terminated franchisees. Although many courts have shown more reluctance in recent years to aggressively enforce non-compete provisions, 2020 actually saw many franchisors prevail with injunctions in this area. And this is a quick survey of a few cases, not an exhaustive review, but the first two cases that we're going to take a look at are from the Liberty Tax franchise system. In JTH Tax v. Magnotti, Liberty Tax terminated multiple franchise agreements with its franchisee in January 2018. And at that time, it reminded the franchisee and its owners of their post-termination restrictive covenants regarding non-competition, non-solicitation, return of customer information. By January 2019, however, the owners of the former franchisee had opened a new tax preparation service within their restricted territory and were actively soliciting former clients of the franchisee. After Liberty Tax filed suit, the court granted a preliminary injunction shutting down the business, finding that the owners had violated their restrictive covenants and gained an unfair competitive advantage because of it. The court was not persuaded that the defendants would suffer a comparable harm that would outweigh the contractual rights for Liberty Tax, because if an injunction were granted, it was merely requiring them to comply with their contractual commitments. Similarly, in JTH Tax v. McHugh a few months later, a Washington federal court granted a preliminary injunction against the owner of a terminated Liberty Tax franchise after she attempted to start a new business within the restricted territory and solicit former customers of the franchisee. The court was satisfied that the restrictive covenants were appropriately limited in both time and geography to be enforceable. Interestingly, shortly before this case, Washington had enacted an anti-non-compete law that the defendant argued barred an injunction in this case. The court, however, concluded that Washington's law only applied to employment contracts, not franchise agreements. The court was not unsympathetic, however, to the harm that would be caused by shutting down the defendant's business with an injunction. And it did conclude that although there was a bond waiver in the franchise agreement, the court had questions about whether such a bond waiver was enforceable. And it wasn't fully briefed in front of the court. So the court did require Liberty Tax to pay a $100,000 bond in case the injunction later proved to be wrongly granted. On the next slide, we have two more injunction cases in which a court did, similarly shut down the defendant while litigation was pending. First, in Little Caesar v. Miramar, the Sixth Circuit affirmed an injunction that had been granted by the Eastern District of Michigan against a holdover franchisee. Little Caesar had terminated the owner of 4 franchises in Connecticut and Massachusetts for various operations defaults in 2018. But nevertheless, the franchisee continued holding itself out as a Little Caesar franchisee for almost a year after termination. Eventually, Little Caesar issued supplemental notices of termination in 2019 and sought injunctive relief to shut down the business. The franchisee lost at the district court, sought reconsideration, lost that, and then eventually took an interlocutory appeal of the injunction, arguing that Little Caesar had not proven by clear and convincing evidence that the franchisee had actually violated the agreement justifying termination in the first place, as well as arguing that Little Caesar's termination was retaliatory. The circuit court noted, however, that the clear and convincing evidence was not a standard required for proof for an injunction, for likelihood of success on the merits. And because Little Caesar had demonstrated that there was an actual breach, or at least that they were likely to prevail on the argument that there was an actual breach of the agreement, its motivation behind the termination was irrelevant to the claims or the sought injunction. Finally, the franchisee did try and argue that Little Caesar had waived any right to an injunction by allowing it to continue operating for a year after the initial termination. The circuit court concluded that this argument hadn't actually been preserved below, but even if it had, it noted that Little Caesar's termination notices specifically provided that any election to delay judicial action would not be considered a waiver, and therefore did not preclude seeking an injunction at a later time. The Marisbeck v. Sutko case had a Tennessee federal court not only enforce a non-compete through an injunction, but also enforced it against a non-signatory to that agreement. In this case, the property inspection franchisee entered into a mutual termination agreement with its franchisor, and both the corporate franchise and its owner agreed to be bound by a post-termination non-compete. Only days after that mutual termination was signed, however, the owner's son opened up his own property inspection company. And the court agreed that the son should be bound to the non-compete, even though he hadn't signed it, because he was in active concert or participation with his father. He had, in fact, been involved in the day-to-day operations of the former franchise before its termination. The evidence suggested that the new company was a mere continuation of the old one, using the same staff, similar name, logo, and actively solicited former customers of the franchisee. There were, however, other franchisors who were not able to obtain injunctions for their non-compete provisions. Now, often a court will grant some injunctive relief to the franchisor plaintiff, but decline to go so far as to shut down the defendant's business while litigation moved forward. That's certainly the case in the first example from the Interim Healthcare franchise, which is an interesting contrast to the Amerispec case. Here, the court granted a franchisor's request for an injunction to stop defendants from using trademarks, the franchisor's marks, but it did not require them to cease operating their competing business. In this case, the defendants had taken over a nursing and in-home care franchise in Louisiana after the original franchisee had its charter revoked. However, the defendants never actually signed a franchise agreement, even though they held themselves out as successors of the original franchisee and enjoyed the benefits of that original franchise agreement. When the defendant's franchise was ultimately terminated by the franchisor, the court ruled that it could not enforce the post-termination non-compete because state law specifically required that such a covenant must be set forth in writing, signed by the party against whom it was enforced. And so even though they were for all intents and purposes working under the old franchise agreement, they had not signed it and the court would not bind them to it. Finally, a third liberty tax case provides an interesting contrast with the earlier two that we discussed. JTH Tax v. White had a franchisee, again, enter into a mutual termination agreement with Liberty Tax, agreeing not to use trademarks, return all proprietary information and customer information, and not operate a competing tax preparation service within 25 miles of the franchise site. But almost immediately after entering into that termination agreement, the former franchisee began operating a competing business in the same location. Although the court agreed to issue an injunction prohibiting the use of Liberty Tax's marks and requiring the franchisee to return proprietary information, it declined to enforce the non-compete provision and enjoin the defendant from operating his competing tax preparation business. The court acknowledged that Liberty Tax was likely to prevail on these claims, but it questioned whether Liberty Tax would truly suffer any irreparable harm that could not be remedied by damages rather than equitable relief. Because the defendant had no employment experience outside of tax preparation, the court was concerned that he would be unable to find work and therefore suffer a more serious irreparable harm from an injunction than would the franchisor. And therefore it denied the injunction as to that non-compete. If we go on to the next slide, the next category of cases similarly relates to a court's willingness to enforce a contractual agreement between franchisors and franchisees. Here, specifically, choice of form or choice of law that may be set forth in the franchise agreement. In the Peruganon v. AFC franchising case, the court declined to enforce a forum selection clause. And again, the case turned on questions of, who was the proper party or who was the party referenced in the agreement. Here, the franchisor was seeking to move a lawsuit from the District of Connecticut, where it was filed by the plaintiff, to Alabama, where AFC Franchising's principal place of business was located. Peruganon, the plaintiff, had entered into a master development agreement with AFC's predecessor in interest, Doctors Express Franchising. Although that master development agreement specifically provided that any dispute be brought within the state or judicial district in which we have our principal place of business, the court concluded that the reference to we and our in the contract referred specifically to Doctors Express, who was the contracting party at the time the plaintiff entered into the agreement. It did not put the master developer on notice that he might be required to file suit in some other state based on the location of a successor in interest's place of business when it later came into the contract. By contrast, in the Sweet Charlie's franchising case, the court decided to transfer to a forum selected in the franchise agreement, even though not all of the defendants were party to that agreement, and none of the litigants actually requested the eventual transfer. Sweet Charlie's Franchising brought suit in the Eastern District of Pennsylvania against a franchisee and other third parties for misappropriation of confidential information that the franchisee had gained while attending a training program for franchisees in Philadelphia. Although the franchise agreement provided for litigation in Delaware, the franchisee sought to transfer the case to Tennessee, where the franchisee was located and where at least one of the non-contracting parties had commenced a bankruptcy action. Now, the court acknowledged that property at issue in the dispute was located in Pennsylvania, which did weigh in favor of keeping it in that forum. And the court also acknowledged that Tennessee would be more convenient for the non-contracting parties, weighing in favor of transferring it to that forum. But even though no party requested it, the court concluded that the equities justified transferring the case to Delaware, as provided in the franchise agreement, which would be more efficient in its view and which would uphold the policy of enforcing such forum selection agreements in a contract. If we go to the next slide, the next two cases deal with choice of law issues in addition to choice of forum. In Lakeside Surfaces v. Cambria, a distributor of tabletops brought suit in Michigan, arguing that the manufacturer who terminated its relationship had violated the Michigan franchise investment law. The defendant sought dismissal because of a choice of forum that required litigation in Minnesota. The plaintiff argued that that would be a violation of the franchise investment law, which prohibited forum selection clauses that required litigation in another forum. However, the parties' contract also included a Minnesota choice of law provision, and the court noted that it was not against Michigan public policy for the parties to agree that Minnesota law, not Michigan law, would govern the contract, especially because the court concluded the Minnesota Franchise Act would apply to, or likely apply to, the plaintiff's claim, and that it would actually provide greater protections than the Michigan law. The plaintiff sought to amend the complaint and add a claim under the Minnesota Franchise Act, but the court dismissed the case, saying any further relief that it would seek would have to be in a Minnesota court. The ACB v. Wizards of the Coast case in the Western District of Washington similarly saw the enforcement of the parties' contractual selection of Washington law, despite the argument from the distributor to invoke the Wisconsin Fair Dealership Law's protections against failures to renew a dealership. Although the court concluded that Washington law did not provide the same protection to the distributor, in fact, in this case, didn't provide any relief under the claim that was being sought, the failure to renew a dealership claim, the court concluded that the distributor had failed to demonstrate Wisconsin had a materially greater interest in having its law applied than the parties' agreement in the contract that Washington law should govern the contract. So in these two cases, we have both courts enforcing the contractual choice of law, even though the impact of the decision is significantly different in both. In the Cambria case, the court said that enforcing choice of law would provide greater relief. In the Wizards of the Coast case, the choice of law would provide essentially no relief. But in each case, what the court concluded was that the choice of law in the contract should be enforced. The final category of cases involving courts deciding whether or not to enforce some of the agreements between franchisors and franchisees is arbitration, where there were some notable appellate decisions regarding arbitrability. First, in the Richardson v. Coverall case, the Third Circuit held that coverall franchisees who were seeking a putative class action must submit their employee misclassification claims against the sub-franchisor who they had contracted with, pursuant to an arbitration clause in that sub-franchise agreement. The appellate court did not go so far as to say that the same rule applied to Coverall, the franchisor, because Coverall was not a party to that arbitration agreement between the franchisees and the sub-franchisor. The Third Circuit did remand the issue for further fact-finding regarding whether Coverall could be considered a third-party beneficiary to that agreement. The court decided essentially that there had not been enough attention to that in the district court below, and it wasn't going to rule in the first instance whether or not Coverall could invoke that provision. Interestingly, in a related case that came out a month earlier, Coverall did essentially prevail on that argument under different relationships. Coverall was able to compel arbitration in a misclassification claim brought by employees of a franchisee, where the District of Connecticut concluded that Coverall was a third-party beneficiary of the franchisee's arbitration provision in the employment agreement itself. Similarly, in Blanton v. Domino's, the Sixth Circuit compelled arbitration of a putative class action involving anti-poaching provision claims, arguing that the anti-poaching provision imposed in employment agreements from Domino's franchisees violated antitrust laws. Domino's moved to compel arbitration, and the district court granted the motion, even though it was based on an arbitration provision in employment agreements that Domino's was not a party to. The court concluded that it was for the arbitrator to decide the threshold issue of whether Domino's could enforce the agreement or not. And the Sixth Circuit agreed. It concluded that the reference to AAA rules in the arbitration agreement said that it would be governed by the then applicable rules of the AAA. And the Sixth Circuit concluded that this provided a clear and unmistakable evidence that plaintiffs agreed to arbitrate all issues of arbitrability. Therefore, it was for the arbitrator to decide whether a non-signatory could enforce the agreement. The Sixth Circuit concluded that was not limited to subject matter of claims and whether claims fell within the arbitration provision or not. It also applied to whether a non-signatory could enforce the agreement. If we go to the next slide, we have another franchisor's effort to arbitrate a putative class action. This in the District of Connecticut, where the court denied a motion to compel arbitration in Solomon v. Subway. In this case, the issue was whether the plaintiff could be said to have agreed to or even been aware of the arbitration provision in the promotional materials that Subway had provided on a website. The plaintiff in this case had signed up to receive text messages from Subway for some initial promotion. But after continuing to receive unwanted text messages, he eventually brought a putative TCPA class action on behalf of other Subway customers. Now, Subway argued that the promotional materials on the website had an arbitration provision and that by signing up, he had agreed to arbitrate any potential claim regarding the promotional materials. The court concluded, however, that the plaintiff had not received a reasonable and conspicuous notice of arbitration terms. It looked at the text that was on the website and concluded that it wasn't clear what the arbitration provision was applying to, whether it was the website or the promotion itself. But the court also concluded that the plaintiff hadn't demonstrated that he unambiguously manifested his assent to those terms. So like the Coverall and Domino's cases, this Subway case ultimately revolved around whether there was an agreement between the parties to arbitrate. But here it was the lack of evidence that he was on notice of the provision, let alone whether he had agreed to be bound by it, instead of simply a question of who should be making this determination and whether a non-party can invoke the agreement itself. Mesa, I'll turn it back to you.
All right, thanks, Richard. Our last topic here is COVID-19 and then what's ahead. So, of course, we would be remiss, not to mention COVID-19 and the pandemic, as that has, provided the backdrop against which, all businesses have been operating this year. Lathrop has put out a lot of resources covering pandemic-related items as they occur. For example, this year we wrote about various filing accommodations put in place by franchise registration states during registration season. We also wrote about the FTC and the DOJ Antitrust Division's joint statement, which detailed some expedited antitrust procedures they had put in place in order to facilitate collaborations between businesses working to, protect the health and safety of the American people during the pandemic. We also covered insurance recovery issues, particularly business interruption insurance, which has become, of course, of great importance during the pandemic. We covered the CARES Act and PPP loans, and we put out a lot of information on various employment issues related to the reopening of businesses. So to find these resources, you can visit our website. We have a COVID-19 Client Resource Center, and the link is up here on the slides. I also just wanted to call out in particular two items that may be of continuing importance. The first is a webinar we did, I think this past spring, called Preparing for Franchisee Bankruptcies in a COVID-19 World. And I have a link to that webinar, the materials and the recording on the slide as well. That likely going to be a kind of an ongoing issue. And also, I wanted to call your attention to our article on some key takeaways from the Nassau and Washington commentaries on COVID-19 disclosures. Again, these are issues that franchises have to continue to grapple with into the coming years. They are considering whether to make amendments to their FDDs. I also mention these, in part because they relate to some issues that we think are coming ahead. So, of course, I want to give a big caveat here. Nobody knows, I think as this year has demonstrated, nobody knows exactly what's ahead or when it's going to happen. But we have listed a few things here we're going to keep our eyes out for. The first is, to the extent that franchisors or other business partners of franchisees have entered into forbearance agreements for example, payment plans, those agreements will likely be coming due as businesses reopen. And of course, we hope that businesses will continue reopening in 2021 for sure. And along with those agreements coming due, we might see a spike in franchise terminations. That's certainly something we experienced coming out of the last recession, and it's definitely a possibility here as well. We may also see an increase in franchisee bankruptcy filings. This is, again, an issue that franchisees and franchisors and their business partners are going to have to grapple with. In the court system, of course, in most jurisdictions, there's a substantial backlog of cases. Most court systems are either, not having trials or having limited trials and hearings. So, as courts reopen and as travel becomes easier, we're expecting to see some of those cases start moving forward. And along with it, probably more decisions coming out. And we certainly observed, Richard and I, as we were preparing the monthly memorandum, we observed a sort of slowdown in reported case decisions, especially at the beginning of the pandemic, and we expect that that may up moving forward. And then, on the business side, to the extent that franchisors have made adjustments to their business systems as a result of the pandemic, they're going to need to consider, which changes or which parts of those adjustments, if any, that they're going to keep going forward. One thing that we've seen a lot of is the adoption of new technology, and including remote work, but also other technological solutions. And we're going to have to consider how that impacts our work going forward. And another area, in particular, we've seen some adjustments are, the adoption of new methods for getting a company's products or services to market. And I'm sure some of those new methods are here to stay, but, we'll have to see what makes sense as, we're able to sort of return to a pandemic way of doing business. I also wanted to call out a couple of legislative issues. We expect that there will be another COVID relief package, either later this year or, maybe more likely next year after the new administration comes in. We're going to be looking out for guidance on PPP loan forgiveness, and also, of course, going to be eye on corporate liability shields, and that might, potentially be part of that relief package. And then, of course, there is, the ongoing review of the FCC franchise rule, and potential revisions to that rule as a result of that review. And then, finally, it's worth mentioning, of course, in any presidential election year like this one, we're going to ask, what will the new administration bring? It might very well have, new regulatory or enforcement priorities, and that might very well color some of the issues we talked about today. For example, the joint employer, the rules governing joint employer, and the direction of case law. Also, arbitration, is an issue that could be visited. So, rest assured, continue to monitor all of these developments and other developments in franchise law closely, and of course, we'll report on them monthly in our franchise memorandum. So with that, I'll say thank you so much for listening to our presentation today. If you have any questions, we'd be happy to answer them at this time. Okay, I'm not seeing any questions at the moment, so I'll give you maybe another minute or so to type them in if you have any. And of course, you can also feel free to reach out to us at a later time. But seeing no questions at this point, I will say thank you very much for attending, everyone. It was wonderful to be here with you. Richard?
Yes, thank you. And we look forward to continuing to provide useful information to you going forward.